talk about then what you do when you have either you're dealing with a complaint or you have a complaint yourself, and then tools for how to resolve it. And like I said, and Jessica said, I'm happy to answer questions at the end. And you know, it's an ongoing dialogue. We're all still dealing with it, and it's been around since the dawn of time. And ironically, the law really hasn't changed at all. I've been doing this for 30 years. I've been the harassment advisor at every law firm I've worked at. I do investigations in the film industry. It's not that the law has changed, it's only that we are not putting up with it anymore. And people are way more aware of their rights. And I think a lot of employers are much more proactive in terms of wanting to ensure they have respectful work environments. Okay, next slide. So like I said, okay, next slide. And I'm going to give you some examples. So at the end of the day, what I would say, it doesn't really matter what what legal framework we put in. At the end of the day, it's about creating and maintaining a respectful work environment. So that's the ultimate goal. Doesn't really matter the legal framework. I will give you the legal framework, but at the end of the day, that's what we're trying to accomplish for all of us, is working in a respectful work environment and ensuring that all of the people that we work with are in the same environment. Okay, next slide. And of course, this is in your own places of employment, you want to hopefully create a safe place for discussion. Certainly this is what this is, and that's what you want to do. Hopefully each of your employers, either if you're the employer representative or you're bringing information back to your employer, they should ensure, like every year, there should be training on bullying and harassment, and to allow your colleagues to have a place to discuss this. Okay, next slide. So there's three sort of the legal framework under which bullying and harassment falls. There's human rights legislation, which I cover, there's workers' comp, and then you have your bylaws and code of ethics and professional conduct, which also govern how people are supposed to behave within your industry as professionals. Okay, next slide. So the first one, so under your bylaws, which you may be or may not be aware, when none of us ever go back to our bylaws to see how we're constituted and what our obligations are, but there are in your bylaws an obligation for an architect to conduct affairs in a professional manner, including refraining from dishonorable or discourteous conduct towards a person or entity, conduct unbecoming, harassment, discrimination, or other failure to comply with human rights laws enforcing Canada, its provinces and territories, and behavior that would reflect unfavorably on the profession. So you as if someone was egregious in their behavior, they could, lose their ability to be a member or be registered as an architect. Okay, next slide. And, you have an Architects Act. There is now going to be a Professional Governance Act, which will govern, all the kind of professions in your space, and then but everyone's going to have the same obligations. Okay, next. So for you have ethical principles that have to be included are having regard to the common law and having regard to the applicable standards. So that's why it's important for you to know what the statutory obligations are under human rights legislation. Okay, next slide. Okay, so under human rights legislation, what is protected? And so by protection, it means under human rights legislation is the highest law in British Columbia. It would be the highest law federally. So if you're a federally regulated employer like banking or transportation, there's a federal human rights legislation. In BC, we have the BC human rights legislation. Pretty much they cover the same grounds. In BC, what they are, and these are the grounds in which you cannot be discriminated against. So you cannot be harassed, you cannot be affected in your employment, whether you're hired or not hired, or you're given a job assignment or not, on any of these grounds. Race, color, ancestry, place of origin, so political beliefs. So, if someone was, trashing Trump and you didn't like that, like they could actually file a human rights complaint to say, I am allowed to have my political belief and not be harassed for that. Religion, religion we think of some of these categories as, if someone would say, well, you can't hire Jews, that would be discrimination on the basis of religion. But I had a situation just with, I'll give you anecdotes throughout from cases and from some of the investigations I've done over 30 years. But for myself personally, like I worked at a firm, and not the one I'm at now, but I had a previous partner who just took great delight in bugging me, like just poking me every day because I'm very Jewish, and I sent my son to the Catholic all-boys school to play football. And so he took great delight in razzing me every day about how could this Jewish mother send her son to Catholic school? And it was meant to be a joke, but at the end of the day, he was kind of harassing me on the basis of my religion. I was affected by it. He definitely hit a chord with me. It hit a nerve with me. I'll tell you how I didn't deal with it effectively, and I'll tell you how it would have been better. But it doesn't have to be the most insidious form of what we say discrimination, the basis of religion is. It can be like that. That's considered what's called a microaggression, which we'll talk about later. Marital status. So that's not only whether someone's married, whether someone's not married, but also who they're married to. So there's a famous Supreme Court of Canada case where a woman who was a bank teller turns out was married to a bank robber, convicted bank robber. She got fired, and then she alleged discrimination on the basis of who she was married to. The guy had been convicted like 20 years ago. It didn't mean that she was now going to be in cahoots with him to rob the bank. So that it's given pretty wide interpretation. Family status, again, it's not only whether you have a family, it's who your family are. So, someone can't say, well, I hated your uncle when he worked here, so I'm going to give you a hard time. So that kind of thing is covered. Gender, identity, or expression, physical or mental disability. It includes perceived disability. So say you had a colleague who went off and got treated for cancer. If you treat them differently, you perceive, oh, now they're not going to be able to work full time or be invested in that project we have because they must be tired from their chemo. Like, you can't assume that someone has a disability. So you can't discriminate on the basis of that. Sex, which would include, that's where discrimination on the basis of pregnancy fits under that category. Sexual orientation, age, and so it used to be you could discriminate against people who were 65 and older. Now we've gotten rid of that, so you cannot discriminate. And conviction unrelated to employment or intended employment. So that's become a bit of a issue. That was always kind of obvious. Like if you're hiring, if you're hiring someone as a bus driver and they're convicted that they have a DUI and they don't have a license, well, then you can discriminate on the basis that they have a conviction. But if it's unrelated to employment, you can't. And, in the film industry, that became an issue because, if someone would, a film would have a certain topic, maybe there was intimacy involved in the filming, and now you find out that the cameraman was convicted of sexual assault like 10 years before. And then people find out about it and they're like, how could the production company hire someone who has a record like that? But you would never, if you're hiring a cameraman for a position, you would never ask them you never do a criminal record check for that. So, but it's gotten, since the Me Too movement, I mean, it's raised issues of, when can you say it's not appropriate? If you're hiring someone as your treasurer, then they can't have been convicted of fraud. So it causes all sorts of interesting issues. So this law is always evolving in terms of where it seems kind of obvious on its face, it can have wider impact. Okay, and then discrimination includes harassment and bullying. So it's not just we won't hire women, it's whether you harass someone or bully someone based on one of these prohibited grounds. Okay, next slide. So that's under human rights legislation. So we've covered what's under your bylaws. Your bylaws incorporate by reference your provincial obligations, which are under human rights. And then under workers' compensation, a person is entitled to claim for a mental disorder that is predominantly caused by a significant work-related stressor, including bullying and harassment. So a few years ago, this was introduced to include bullying harassment can form the basis of a work safe claim. So, all the legislation has been pretty accepting that these issues can cause someone significant stress in the workplace, enough that it's no different than if they, broke their leg at the office. It can cause someone to have, and it can manifest itself physically. Some people it'll manifest, they'll have brutal stomach aches if they're being subjected to bullying and harassment, or they will have a depression and they'll be avoiding work. So thankfully the WorkSafe has acknowledged that these issues can manifest themselves in a pretty serious way for people. Okay, next slide. And again, the threshold for WorkSafe is a little higher because you have to be diagnosed by a psychiatrist or psychologist as having a mental or physical condition. But it's also carved out that it's not whether someone has gotten disciplined, right? An employer can still performance manage somebody without that being the basis of a complaint. Now, it's one thing if you gave someone a poor performance review versus whether you're screaming at them because they're an idiot and they didn't do their job right. So, it's how you deliver the messaging, but that's carved out. And the only reason I acknowledge this or identify this is that under human rights legislation, you don't have to have gone to a psychiatrist or a psychologist to say you're impacted by it. The Human Rights Tribunal accepts that people are going to have, it's going to have an impact on somebody if they are bullied or harassed on any of those prohibited grounds. Okay, next slide. So this is under WorkSafe, but it's really the same interpretation or definition under any of these headings. It's bullying, it's whether it includes any inappropriate conduct or comment by a person towards a worker that the person knew or ought to have known would cause the worker to be humiliated or intimidated. So I always think of it, if I wouldn't want someone to say it to my son or my daughter or my brother, then don't be saying it to your colleague. Like if you put yourself in those shoes, that's where it's like whether you knew or ought to have known, the person doesn't have to tell you, oh my God, that's an offensive thing for you to say. Every person has to take a step back and say, how would that impact the person who's at the receiving end of that comment? Everybody thinks they're funny. When people tell racist jokes, sexual jokes, they think they're being funny. I mean, I have done investigations for 30 years. Some people know that what we're doing is wrong, but with the quote lighter stuff, it still can have a huge impact. And some people you can allege they ought to have known that's not welcome conduct, especially nowadays. And we've talked about how each generation gets a little more savvy about what's not acceptable in the workplace. And so now it's even more of a thing whether someone ought to have known they shouldn't be saying that. Someone apologized to me in a earlier conference I was in because it was all women on the screen, and he came into me, he's the exec director of this organization, going, hey guys, I mean, I'm not offended by that, but other people are. And so you kind of have to start to know your audience and think about your language. So, I mean, that's a small thing, but whether you walk into, a group of 100 women and you say, hey guys, right? So anyways, next slide. So obviously, if you do not deal with these issues, which you probably all know, there's huge implications. So if you are here as management in your organization, right, the impact can be significant. I mean, you have health and safety issues. You've got psychological and physical injuries, which can result in very expensive WorkSafe claims. There's always lower productivity, lower morale, higher absenteeism, staff turnover, and really critically for recruiting is bad reputation. I mean, people are aware out there what their rights are, and they're not going to want to work for a company that doesn't deal with these things effectively. You're in a small industry, I'm in a small industry, everybody, we all kind of know each other within, like, I work in workplace law. All the lawyers at my level all know each other. If you're at a firm where you've heard some bad situation happen and the firm didn't manage it, the next year, you're not going to attract students. So it's really critical, not only and most importantly, do you want to maintain and ensure you have a respectful work environment, but it's hugely going to impact your business if you're not dealing with these things effectively. Okay, next slide. Okay, so bullying is personal harassment. It's causing intent to others through verbal verbal harassment, and more, sorry, I'm just getting an urgent message. It could also be like isolating a person. So, freezing a person out can be a form of discrimination. So if someone, usually it's where there's a power imbalance. So if it doesn't always have to be a power imbalance, but it can be a power imbalance, which is the more where someone says, well, if you don't do this for me, then I'm going to take away a work assignment, or I'm not going to give you a plum assignment. So that's kind of more bullying. It's kind of the schoolyard bullying, right? Where someone who looks like they have more power is trying to use it against you. And where it is on any of those prohibited grounds, that will form, that's part of discrimination, right? Bullying on it, bullying a person because of their age. Okay, next slide. So, these are examples from cases, deliberately withholding information on a file, right? That could be a form of bullying. Cutting someone off, obviously ostracizing, anything where someone isn't treated the same, right? So hypercriticism, someone who's like spying on someone, just making someone uncomfortable in the workplace, that's going to be is going to be bullying. Okay, next slide. Same thing. Harassment is whether you're, and it's not necessarily whether you intend. When I've done investigations, the harasser always said, well, I didn't intend to make that person feel uncomfortable. I don't know if anyone really intends to be an ass when they're like making these comments. Like I said, a lot of the times people think they're funny, or they think, oh, well, if I say enough comments to the person, they'll go out on a date with me. And so at the end of the day, it's whether even someone embarrasses a person, that's going to be included in personal harassment. Okay, next slide. And if someone, an employer is going to be liable for the sexual harassment or bullying, it doesn't matter, or bullying or any form of harassment on any of those grounds, if it's committed by an employee within the scope of their employment relationship. So that's a difficult question, because the human rights legislation has gotten wider and wider in terms of what's the employment relationship. Where is employment, right? It's no longer in the four walls of your office, right? If you're at an industry conference, or you're at a client meeting, or you're on a construction site, if you get harassed by a coworker, that's within your employment relationship. If you are asked by your firm to go attend an industry conference, that's the employment relationship, and the employer is going to be liable if one of your coworkers says something inappropriate to you. It gets more difficult when you're at an industry conference and somebody else from another firm says something to you, and that's where an employer has to take steps, and we've done that before, where the employer can't just say, well, it's not my employee, so I'm not going to deal with it. They have to say, we're going to take it. We are going to take it seriously, and we're going to contact that contractor and say, we're not going to put up with that person being treated like that by your employee, right? So I think a lot of employers, like we had a courier company who would hit on our receptionist all the time. So it wasn't our employee, it wasn't her coworker, but in her workplace, she was getting hit on by someone who was coming into our workplace, and we had to talk to the courier company, say either don't bring that person here, or have them come here and apologize and not treat her that way. But at the end of the day, the employer is always going to be responsible for managing those things. Okay, next slide. Again, it's the unwelcome conduct of a sexual nature. So it can be where it's tit for tat. You do this sexual favor for me, and then I'll give you a plum assignment. Or conversely, if you don't do it for me, then you'll get an adverse job consequence. Or it can be just a demeaning practice, where someone, if you work in a situation where there's a sexualized work environment, which we all, and it's the difference between someone saying, oh, you're wearing a nice sweater, versus like, oh, you fill that sweater nicely. I mean, we know where it's laden with sort of sexual innuendo, and that's creating a sexualized workplace, and that's what's not allowed. And this case is from 1989. So like I said, the law has not changed at all. It's only the way it's managed in workplaces and enforced in workplaces, and where women and men, anybody, are taking steps to say, I'm not going to accept that anymore. So, which is great news. And that's a lot since Me Too. I mean, obviously there's been human rights tribunals been around for 30 years, but there's more and more, I think more and more identifying that this is not going to be okay. This is not what makes a good work environment. Okay, next slide. Next slide, same thing. And the interesting thing, again, is that it's not that a person has to say they object to the conduct. It's that the conduct has to be unwelcome. So it's whether it's, you know, an objective, it's based on an objective standard. So if someone makes one, if someone said, oh, hey guys, and the person goes, oh my God, I'm going to take a month off work. That was like such a horrifying comment. I'm so, you know, it demeans me as a woman. Well, that's an overreact. That's not going to be seen as a reasonably objectable comment. But it's whether it's unwelcome. Again, the person doesn't have, you don't have to say to the person, this is not okay. And each of your places of work should have policies where this is identified, so people are aware that this conduct, you don't have to object to it for it to be unwelcome. It's kind of sort of implied that it would be. Okay, next slide. So again, this is just an example of a case. It was in a sleep country, you know, mostly men working on the sales floor. One woman worked there. It was like 8 hours a day of constant sexual comment about the beds and who was going to use the bed and what they want to do with the customer who came in. And, you know, she participated in the sexual banter because she wanted to be, you know, she didn't want to feel like she was ostracized. But at the end of the day, her manager was there every day, seeing that it was happening every day, and didn't do anything about it. And she did not have to step up and say, that's not okay for me. The employer had the obligation to say, to identify, this is not okay. Okay, next slide. Next slide. Now, again, it's whether the banter is unwelcome. So it's a fine line, right? It doesn't necessarily also have to be, you know, like I said, people, or what we said maybe before the slideshow started, that it's not supposed to take away banter in the workplace. People still meet each other in the workplace. It doesn't mean people can't date in the workplace. It's whether that banter is unwelcome. And so, you know, and it's also, it doesn't have to be direct banter. So say, you know, if you're having a conversation with somebody and it's kind of laden with sexual innuendo, it may be between the two of you people having that conversation. But say there's another staff person or another person who's working at their station or their carol, and they're hearing all of this. It's not directed at them. That's creating a sexual work environment for them. So even though the two of you may be in a conversation and having, you know, a flirtation, you're creating a sexualized work environment for the person who may be sitting just adjacent to you, even though it's not directed at them. That's also sexual harassment, creating that sexualized work environment. So again, you have to, if everyone's behaving respectfully and no one's saying something that they wouldn't want anybody to say to their, like I said, sister, brother, uncle, then, you know, that's where it shouldn't be in the workplace. If people want to go outside the workplace and flirt all they want at a bar, that's not something the employer can manage. But in the workplace, that's what should be managed. Okay, next slide. So the other part of this is microaggressions. And so, like I said, a lot of this isn't about people making, like, we're not going to hire Jews. Like I mean, those days are gone, thankfully, right? We've evolved as a society. But where it can be, I think, sometimes more insidious is what we call microaggressions. So that's more subtle behaviors that affect members of marginalized groups. And all the studies show the people that are in those categories of those marginalized groups feel great discomfort over time. And it can appear as over discrimination, abuse, or harassment. And sometimes it's unconscious behavior. Sometimes we have language that creeps into our lexicon. Maybe we heard it from our parents or grandparents. And, you know, I was shocked, again, not at this law firm, but a law firm I worked at for 17 years. And I worked with a senior woman who I totally respected. And one day we were talking about a settlement discussions. And she said, I think he Jewed me. I'm like, did I just hear, like, did you just say what I thought you said? I was like, so shocked. And the minute was out of her mouth. I don't think she'd ever met another. She never worked with anybody Jewish before. I don't know if you could tell I'm Jewish. A little bit vocal about that. But like, she stopped in her tracks the minute she said it. And I'm like, that was so offensive. But she'd heard that her whole life. She'd used that expression without even thinking really how offensive it was. So it's those kind of comments, next slide, that can really add up. And this is where we all do it. Sometimes it's seen as a compliment in the eyes of the person who said it. It's kind of like, oh, well, some of my best friends are Black. Like, that's offensive to that group of people. It can be, a woman getting judged as harsh or being difficult when she speaks with authority in a meeting. But if a man does it, he's just being confident. And it's sometimes unconscious bias. It's, what people come into the room with. Okay, next slide. The micro, I love these expressions. These are all from the recent studies on this. A micro invalidation, I love that, where someone says, I don't see color, which essentially they're saying the exact opposite, right? Or like, some of my best friends are Jewish, or whatever it is. Those are the kind of comments that we're also trying to help people see are inappropriate. Okay, next slide. And it can be subtle, with actions or symbols that display insensitivity, saying something that might not outright appear to be, but is disrespectful or offensive to a marginalized group. Okay, next slide. You probably won't want to work after having a baby. Right, because I went, to 7 years of architecture school, and now I'm just going to flush it down the drain because I had a baby. So, I was told as a junior lawyer, you could either have a career or you could have children, but there's no way you could be a successful lawyer and do both. Well, I'm proof that that's not the case. I have a family and I had a successful career. But those are the kind of things, and I still hear people say that. I still hear, some of the partners, male partners in my office will say that to a female partner. Like, really, she's spent, 20 years in school only to be told, like, you're not gonna be able to do both. So when are you really going to transition? And I mean, that was a comment that came up in one of the cases. Where are you really from? When they say, oh, I'm Canadian, right? I do a lot of immigration work. I've heard that, and someone asked that. That's not okay. Or your name is too hard to pronounce. I mean, those are all, like I said, they're subtle, but they're forms of discrimination and harassment as well. Okay, next slide. Again, these are, I can't believe you did this. Your disability is so inspiring. Again, highlighting the very feature that the person doesn't want to be identified by. You're beautiful for a transgender girl. Wow, you look great for your age. Those kind of things. So, it's just a reminder, we all have them. You can go to the next slide. We all have them in our, in our daily phrases. And it's just something to take a step back to say, do I make those kind of comments? And, as we hopefully get a more diverse and inclusive work environment, that we have to be more aware that, there's lots of subcategories that are not, they don't seem so egregious, but you're not that at the receiving end of it. So it's just a reminder that those things are not going to be tolerated. So, for every workspace, ideally you want to have prevention. Like I said, it's going to be around since the dawn of time. But if you're here and your workplace does not have a policy, you should go back to them and say, like, why don't we have a workplace bullying and harassment policy? You are obliged as an employer under WorkSafe to have a bullying and harassment policy. So under WorkSafe, you can be bullied and harassed for any reason. It doesn't have to be based on a prohibited ground, but every employer is supposed to have a a bullying and harassment policy, and formal training for those who are either implementing the policy, who are taking in investigations, and how those complaints get investigated and corrected. So if your workplace doesn't have a policy, it behooves you, you're here, you've heard this, most of this presentation, to say, why don't we have that? We should have that, because people forget about this stuff. They don't think about it. And I know nobody really wants to talk about it, but we all have an obligation to bring this forward and keep people accountable for what they say and how they make people feel. And we all, like I said, we all have expressions that maybe we need to rethink that can have this impact. Okay, next slide. So I just tried to find, there weren't many. So to see if your industry, sometimes when I do specific, these kind of presentations within a certain industry, will go to see, have there been a lot of cases? You don't have a lot of cases, which is good news. So there's not like a hotbed of sexual harassment, at least that's reported to human rights. Sorry, this was a case most about that if you're going to do it, you got to make sure you get that. If you're going to file a human rights complaint, you got to make sure you get it in right. So my colleague just put this in because it was against an architectural firm, but it really wasn't about, there was nothing in it other than you have to file in time. So we can skip this. Next slide. Okay, so this is where it was by a consent order. So this is where it was a complaint. So an engineer in this case admitted to engaging in unwanted conduct while in a position of authority. So he positioned himself closer than was appropriate for business communications. And while doing so, sometimes deliberately made physical contact with her. So that's where, you know, if someone's sitting too close, that can be a form of harassment. Right. So even though he wasn't propositioning her, he made her feel uncomfortable. It was a person who is in a position of authority. So, and there's an egregious case that was out of UBC many, many years ago, where it was a PhD student in forestry, and she had to go to a remote location with her supervising professor for her PhD. And she was like the final stages of her PhD. So they go to this remote locations before cell phones, and they get to this, you know, they do their research during the day. It's all going fine, whatever, they can pond scum out of whatever. And then they get back, there's like one little motel in this like remote little area. And when they check in, he says 1 room. And so she is like very young, and this is her, and she's kind of looking at him, and he's not making any moves to say, well, she needs a room too. So she actually goes to the room with him. She spends a weekend with him. She actually has what he thinks is consensual sex. He thinks he's now got a girlfriend. And, you know, she goes through the whole thing. She does her research. They come back to the city. The minute she gets back, she reports it to her employer saying, I was in a complete, you know, I was in a submissive position. I'm in the final stage of my PhD candidacy. This is the person who's approving it. You know, I didn't have anywhere to call. I didn't know what to do. And so I felt I had no choice but to go through with it. So even though it may look like it was like informed consent, it wasn't. And the university got huge damages. It was one of the biggest cases. I mean, this is years ago. And for BC, we don't have huge damages, but it was a significant case because it was such egregious conduct. And then since then, of course, the university put in, you know, if there's 2 people traveling, they always have to have separate. They put in a whole series of things that should be kind of obvious. But here it's where, you know, sometimes it, you know, that was very obvious. But here, this was just like, he just kept rubbing up next to her. Now, he at least admitted that it was unwanted conduct, because I'm sure he knew if we went to a hearing, he may have been much more seriously reprimanded than he actually was in the end. Okay, next slide. You know, he made comments about her appearance. He also requested and received hugs from her. So again, you know, some of us are, you know, I'm a touchy-feely person. I touch people when I talk to them, but don't hug your colleague unless unless you know them really well. You know, if you're, you know, someone who's contacting someone after hours for non-business purposes or asking to perform tasks that are unrelated to employment, that's not acceptable. And, you know, in this case, the employee or the engineer, she was an engineer as well, she said that I'm uncomfortable, and he still didn't stop. She wasn't obligated to do that in order for there to have been probably a complaint. It could have also gone to the Human Rights Tribunal. In this case, it went to your regulatory body. But, you know, there are, you know, this is from 2021, right? This is going to be impactful, where someone does these things. And like, again, it can be insidious stuff. No one should be contacting someone for personal reasons after hours unless they're friends, right? A supervisor shouldn't be doing that. You know, and then we even have legislation, and that was more about work-life balance in Ontario, but you know, you can't contact someone after business hours. So, I mean, you have to think about that, right? You're intruding on someone's personal space, and someone may feel very uncomfortable if their supervisor is sort of invading their home space. So you have to be mindful about that too, and how it's perceived by the person at the receiving end. Okay, next slide. So he agreed, he got a 6-month suspension, and he had to take sensitivity and boundaries coaching, which is horrifying. Nobody wants to be sent to that. It's like going to the gulag. So, you know, and he had to pay legal costs. So if you were involved in this, so this is not only like, if it had been a human rights thing, yes, his employer may have been responsible for him, but this is where, you know, it was pretty serious professional implication on him as an engineer, as it would be as an architect. So it can have bite. So you don't want to be, hopefully you don't want to ever be the person who is subjected to, being part of this regulatory process, but also know that you have the ability, if one of your colleagues who was registered under this, or society, or not society, registered under this regulatory body, you have the ability to file a complaint. I know that's an extreme thing, but at least it has bite. Before, people used to get like a slap on the hand. And now we see in the cases that the regulatory bodies, tribunals, courts are becoming way more sensitive to, we need to have a bigger bite so that this behavior stops. Okay, next slide. And, again, if they had if they'd had training at whatever this guy worked at, maybe it would have caused him to stop and think, oh, I really shouldn't say that to someone. I really shouldn't pull out my chair right next to somebody. Because people think they can get away with it. People think that they have no, either that it's welcome because I'm like the sexiest person in the world, and why wouldn't that person want me flirting with them? Or they just don't see their own behavior. And if you have, if it happens in your workplace, sometimes the most effective way is just to tell someone it makes them uncomfortable. So I had a situation at my last law firm. Well, no, that's not true. At this law firm where, so I have a senior old, like, God love him. I worked with him. I worked with this man for like 30 years. And he is just old school, right? Like if I had a cigarette, he would have leapt across the room to light it. He, guy pull out chairs, whatever. I don't mind that. But he also made very sexualized comments, not to me because I wasn't his prototype. But I had this one younger woman, female lawyer, came to my office. She said, I went to go see Joe, and I showed up in his door, and he says, he's on the phone. He's like, oh, so-and-so, I've got to go. There's like a beautiful young woman at my doorstep. And so I said, it's okay, I'll go talk to him. She's like, oh, no, I talked to him. I go, oh, okay. She goes, yeah, he got it. I'm like, wow, that was brave, because like 5 years ago, there's no way a junior lawyer was gonna like go to the guy in the corner office and say that was not appropriate. So I go to see him, and this is a man I'd worked with at 2 law firms. Literally I worked with him for 30 years. I had given him, and he said, Melanie, I know why you're here. I know. He's like, you have told me probably like 1,000 times, I've had training, I've been spoken to independently about my behavior, he didn't call it like how I, my comments, the language I use. But to see that young woman say those things to me, and imagine that if my daughter was at someone else's doorstep saying those things to her, it's like the first time it hit me, because no one had ever said it to him directly. None of the people that he made feel uncomfortable had ever felt confident enough or in a safe enough place where they could go and talk to him, like approach him directly. And for the first time, when he heard it directly from the person he was offending, it actually made an impact for him for the first time in like 30 years. And that was really remarkable. It was a simple thing. She just said, in that moment, this is how you made me feel. You made me feel like I'm not here for my professional services. Whoever you're talking to on the phone certainly doesn't think like all the female lawyers here are like worth their salt, because all you said to him is there's a beautiful, young lawyer in my office. And it made him stop and think. And, sometimes the most impactful way is to do it directly. Sometimes that's hard. I myself, like I am, 57 years old, and someone actually in my office, one of my partners said something to me that made me really uncomfortable. Like it was really uncomfortable. And here I'm like, oh my God, I've been doing this for 30 years. I give this training all the time. I was so tongue-tied by what he said. I couldn't respond in the minute. It took me like 2 weeks to get up the courage to think about how I was going to approach him, because I wanted to maintain the relationship as my professional colleague. But I needed to let him know, and I couldn't have go to my managing partner, say, I need you to go talk to so-and-so. I needed to do it, but it was really hard. So I appreciate that sometimes going direct can be difficult, but it can sometimes have the most impact. And then if you can't go direct, then presumably in hopefully your policies in whatever place you're in, you will have the ability to report it to whoever you're working with, or if you're the one who receives those complaints, to then make sure they're properly investigated and quickly. And then if it can't be resolved internally, then it can go to, a human rights tribunal. You can, sue in civil court if it is impacting your business. And at the end of the day, it's just good business sense to maintain a respectful work environment. If you're here as an employer, have obligations to maintain workplace free from harassment, and then to report if there's any WorkSafe claims to WCB. You don't have to self-report to human rights, but if you have a situation in your workplace where someone comes forward to you and says, I'm under an incredible amount of stress, or I'm taking a stress leave because I've been harassed, that's a workers' compensation claim that you're going to be involved in. And of course, like I said, it protects your business reputation, because nowadays our candidates are very, very aware of who's not a good employer, and they will do their homework to find out what it's like in your workspace. So that's kind of, I railroaded through it, but I just wanted to give you the highlights of, what the law is, what it protects, and what you should do. If you're at an industry event, sometimes you can't protect your, you can't make sure that the customer or your client isn't saying the wrong thing. But if you see one of your colleagues being harassed, you can certainly step in. Like, it's just having each other's backs to feel like you're not going to let that happen. You're either extricate the person from the situation, or just let them know that you have their back, that you're, and long are the days, in law firms, and I'm sure with you, if you had your architects going to speak to a client and that client was harassing them, gone are the days, well, that's our biggest client, like, suck it up, buttercup, like, you just gotta go, take it on. You don't have to do that anymore. Most employers, law firms will, I'm sure architectural firms will, engineering firms will do this. They will go to that client and say, you can't talk to our people that way. We won't allow that. Or you have a subcontractor on a construction site that is behaving badly and harassing the first aid woman, like, that's not going to be tolerated anymore. So we do see there are definitely steps towards making this better for everybody, but we're still, it's a process. Would you need a lawyer? You do not need a lawyer to deal with being harassed. What you would do, if you're the person being harassed, then you would go to your employer, whoever, hopefully there's someone identified, either in HR or either as a harassment advisor, and you just report it. And hopefully, like I said, a lot of times, if it's not an egregious thing, these things can be dealt with directly. Like the guy who made the stupid comments about, sending my kid to Catholic school. I blew up with him after he said it for the 20th time. I tried to joke with him. I tried to brush it off. I should have just said to him after like the 5th time he said it, I should have sat down with him and said, you know what, it makes me uncomfortable. Don't do it again. And that would probably be the end of it. But I let it fester. I didn't know how, I was much younger, and I just didn't know he was a senior partner, and I didn't know how to deal with it effectively. But you certainly don't need a lawyer. You should start informally. And if that doesn't work, then you take it up, then you make a formal complaint. If you were to go to a human rights complaint, yeah, then I would use a lawyer, because you want to make sure you know what to claim. Okay. And sorry, and with human rights, you only have 6 months to file a complaint. Mm-hmm. So you don't want to, if you have it, you should go seek legal advice, so you know that you don't miss a deadline.
Great, thanks. Just a reminder, if anyone wants to enter questions, you can do it in the Mentee, which the code is up on the screen, or through the chat, or shout it out if that's what you want to do. And you can like these, and then they'll boost them to the top. I'm just going to go through in order. So yeah, next question. Okay. How do you deal with harassment?
This is really critical. This is a hard thing, right? And we deal with it. How do you deal with contractors or consultants, which are not your coworkers? You're not employed by the same employer. You say the partners have noticed, but just want to get the job done. That's not okay. You have to be more forceful to say, that's my work environment. I should not have to be putting up with that. And so it's a fine balance. I mean, sometimes I've heard that, if people feel at least they're being validated, like, I know it's brutal, we're going to get you out of there, we're going to talk to the contractor. I mean, as long as they're not just paying lip service to that, but I think you have an obligation, if you're feeling that you're dealing with that. I mean, the employer should making sure that that's not okay. that they're going back to the contractors, the consultants to say, we will not let our people be treated like that. There's some clients I have, they're big engineering firms, they will not put up with that. They deal with it. But they're big, right? And maybe if you're a smaller organization, it's a little bit more challenging to go back to your contractor consultants to say, that's not going to be acceptable. But you as an employee of whatever firm you're working in, or going back to those partners to say, you know what, that's actually not okay. That's not enough. We don't feel heard. We feel vulnerable. It's not okay until someone finally, it's only where people, it's only if we make noise that we get heard. Like for how many years did what happened in the film industry happen? Until Me Too, until enough people spoke up. And like I said, I deal with it every creative industry. In the music industry is like the worst, right? Because that was part of the gig, right? If you're a rock star, you get to walk in and make sexual comments to anyone you want to work at. Well, you know what? If you're the receptionist sitting there, you do not have to put up with that anymore. So eventually enough people will file lawsuits and complaints where, if that partner, if someone at that architectural firm files a WorkSafe complaint or a human rights complaint, like that's expensive. So sometimes I get the attention of my employer saying, how much that costs, and soft costs, time away from the office, investigating, the worry of what's going to happen. Usually there's a financial payout. And you could have stopped it with a call to the contractor saying, rein your person in. Probably would have been a 10-minute call. Right. So, I think we have to, like I said, make noise. That's the only way it's going to get changed.
Yeah. All right, I'm going to move on. This is another topic.
Yeah.
Okay.
Sounds like someone asking for a friend. How can a pregnant woman be well prepared for background comments? Yeah. So that's the thing, like I said, like, oh, you're going to come back to work? Like, so I think, and when they're on 2 consecutive maternity leaves, look, I've lived that. I had 2 children. I was working, full time. I get that it's hard. You just have to, my approach, and I've counseled, I mentor younger lawyers, is to be absolutely confident in, this is what my plan is. This is my return to work plan. I'm coming back on this day. I'm hitting the ground running, or whatever it is, or you're negotiating part-time, or whatever it is you're doing. And you just have to be confident in your, like, I think I've been successful. I work part-time. I've been work part-time for like 15 years. I'm full-time partner. I'm a full partner, but I work part-time. And that's because I never treated my job like a job. It was always my career. So I think if you are confident in what you bring to the table, regardless of whether you took a maternity leave, you're just confident in what you're bringing back to the table. And if someone makes a comment, then you squelch them, you push back, and you just have to be confident, like, I'm back with my full education experience, hitting the ground running again. And you just show them you're going to do it. So I think it's just, it's putting on a bit of armor to know that you have every right to be back there. And it's no different than someone else who went on a sabbatical for a year. They're just coming back with the same person they were before they went on the leave, and you're just picking up where you left off.
Yeah, and you had every right to leave as well.
You had every right to leave, right? And, so I think you just have to be confident. So, okay, so very fair question. If you're in a small firm and you don't have anyone for HR, what do you do then? Well, then you have to go to whoever the most senior person is in your, that's the only person who can really make a difference. Now, if it is the senior person, right, which can sometimes be the case, then you might have to, either decide whether you're going to file a human rights complaint. That's where it's very challenging, right? Whether you have the confidence to go to the senior person who's doing the harassing to say, I just want to talk to you about how uncomfortable I feel. I know, I appreciate that can be difficult. If you don't have anyone to report to, you just have to go to the most senior person there and say, this colleague is making these comments. I'm really uncomfortable. Most employers these days know that there's liability, there's bad publicity if they don't act. And if you complain and they fired you, well, then you have then you call me. Then you have a human rights case, right? You could file a human rights complaint. Unfortunately, there's not much else you could do other than to go to a formal complaint. But I would always go to the most senior person and say, yeah, I would go to the most senior person.
Okay, I'm going to jump in with a question from the chat that's kind of related. So the question is, for smaller organizations without an HR department, are there any resources, examples, templates for WorkSafe appropriate bullying and harassing policy?
Yeah, there are on WorkSafe. The WorkSafe has a template on bullying and harassment. It's not human rights, but it is WorkSafe. There's a policy and there's there's resources there. The BC Human Rights Tribunal has sort of employer guidelines of what harassment and bullying is. So yeah, there are resources at Workers Comp, WorkSafe BC, I should say, and Human Rights Tribunal.
Okay, I guess this is a similar question if there's any resources, but
well,
conversely,
those are specifically where you would file a complaint.
Yeah.
So I don't know where you would resources in terms of dealing with it, in terms of, you know, I don't know, like law, as lawyers, we have the ability to get counseling as part of being a lawyer, right? I don't know if you have that in your regulatory body or your professional body that gives you allocation or resources to counseling.
That I think that would depend on your employer and your benefits.
Right.
Yeah.
But like, it's not like, as a lawyer, no matter where I'm working for, if I'm a lawyer in BC, we have access.
No, we don't.
Okay, so not
I think
for
we have that, sadly.
Yeah. So yeah, that would be tough. But I would go Workers Comp. I think has some pretty good resources. WorkSafe, I should say.
So I've had issues with microaggressions, ongoing bullying that led to stress leave with a coworker, but he's really good at his job. What is my employer's responsibility?
Okay, the really good at his job, totally irrelevant. And you know, 10 years ago, Matt Lauer wouldn't have gotten fired, right? Or Roseanne Barr, whoever makes the, you know, these brutal, I mean, Matt Lauer was like a sexual predator. Like Roseanne Barr was just like made idiotic comments, right? You know, back in the day, or even at a law firm, if you heard like a client was making those comments, you'd be like, oh, but he's our best sales guy or our best client. Like those days are gone. That is not okay. And if the employer was taken to Human Rights Tribunal, and that was not be a defense, but he's really good at his job. If someone is in your workplace, regardless of whether they're the superstar and they're creating a sexualized work environment or bullying or harassment to the point where someone, you know, is that stressed out that they're almost ready to take a leave, then the employer is not managing their responsibility. And that could result in either the employee filing a complaint to say, I was constructively dismissed because there is a toxic work environment that the employer didn't manage. And being really good at the person's job is not a defense to bullying. So the employer has totally failed if they haven't dealt with it, and then that was their response.
Great. So we're at 7 o'clock, but we still have, there's quite a few questions. I'm wondering if everyone's okay to take like
I'm happy to,
maybe just 2 or 3 more.
Yeah, I'm happy to do that.
Okay.
Oh, 6 months for human rights.
Okay, that was a quick bonus questions. With lots of people working from home, is it acceptable for employers to give preferred treatment to those who choose to work in the office? That's interesting.
Yeah, because working from home is not a right. I mean, unless you have an accommodation issue, accommodation meaning like I'm physically disabled and I need to be at home, or I have colitis, so I've got to be nearby. Like, no, that you don't get protected because you prefer to work at home. Most of us as employers could say, you know what, I want everyone in the office. And if we wanted to do that, we could. It wouldn't be good for morale. We might have a lot of resistance. But yeah, you can get preferred treatment for those who choose to work in the office. Yeah, because most of us were supposed to work in an office. We always worked in an office. It's just because this weird plague happened. And so things changed. But no, that employer can oblige someone to work from the office. That was always the condition of our employment. It's only because the pandemic came that forced us all to work at home. Yeah.
Right. So. But yeah, that's changing quickly.
Yeah. Hey, everybody. Hey, folks. I hate that expression, but I just now use hey. Hi, everybody. Hi, y'all. That's a very southern thing.
Okay, maybe just 2 more questions. Okay, how do you deal with, this is interesting. Yeah, requiring a professional dress code.
Without being harassment. Well, again, it's about Yeah, like we've had certain situations in our, in every law firm I worked with where some of the, and it's not necessarily even the lawyers or some of it where someone's wearing revealing clothing or like shorts to the office. So at the end of the day, we're just saying we want a professional dress code for everybody. So as long as you don't specify, well, women shouldn't wear like low cut shirts, like as long as you say everyone should dress professionally, that's not harassment. If you had someone who in your workplace was constantly dressing in a sexualized nature, and then you'd want to have the HR person, we've had that too, talk to them and say, we are in a professional environment, and that's creating a sexualized work environment. It's no different than having, it's funny in this law firm too, back in the day, this is, I don't date myself, where people used to have like Pirelli, whatever, there were, scantily clad women draped over cars, and they were up in mechanics, but people had them. And then I had in my office, there was a woman at her one of the staff, a secretary of legal systems, and she had at her desk a whole bunch of calendars of like naked firemen. And the men, like some of the junior lawyers came to me and were like totally offended. Like it made them feel uncomfortable. They were sexualized. Like they felt exploited. It was like so funny that these young guys were now totally offended by the fireman calendar, right? So I'm like, well, that's an interesting twist. But at the end of the day, if it creates a sexualized work environment because someone's not dressed appropriately, then you can manage that. It's really no different than someone who's wearing scent that has an impact on the work environment, right? Now people are sensitive to scent. It's not a discriminatory thing to go to them and say, you know what, we're trying to maintain a workplace where everyone feels comfortable, and you wearing that perfume doesn't make people comfortable. There's a lot of people who are uncomfortable physically from that. So I think it's the way it's managed, but it doesn't have to be harassment.
Great. Okay, what kind of off topic, but is it true that a past employer can't give you a bad reference, preventing you from getting another job?
That's about defamation. Well, it's kind of like defamation. The defense of defamation, if it's true, but it's very difficult to assess. How does an employer can say assess that someone didn't do a good job? There's nothing illegal about an employer giving a bad reference if they're vicious about it, or they prevent you from getting another job. They're entitled to say their truth. Most employers, because they don't want to get in a situation, will just do confirmation of employment. But this person worked as a intern from X, Y to Z, and they had these duties, and they will not get into performance. But it's not illegal for an employer to give a bad reference.
Right, as long as it's truth.
As long as it's truth. Right. And conversely, if you gave a great reference to somebody, and then the new employer hires them and then finds out that they were, wanted in 7 states for fraud, right? Then that new employer could sue the old employer, right? So people just stay very neutral.
Right, that's interesting.
Yeah.
Okay, I'm going to do the last question.
Okay.
Surprise question. Okay, you mentioned physical symptoms related to bullying and harassment.
That's a good idea.
Are there other signs we should look
at?
A
lot of it, because a lot of it will happen. It's he said, or he said, she said, like no one was there to witness it. So you have to look at objectively. If someone brings a complaint forward and says, oh, so-and-so make these horrible comments and I hate him, and then they're seen out for lunch every day, that's kind of like objective evidence that maybe there's not really something there, that there's something else going on, or she's trying to retaliate or punish him because he broke up the relationship. But if you see someone who's coming in late, who's crying in the bathroom, who just isn't themselves, then an employer cannot turn a blind eye to that. And you have to start asking, like, is there something going on, right? That's like corroborative evidence that something is happening, right? If there's no sign, someone can say, I'm so depressed, I can't work, but then they carry on and they go out for lunch and they go to the gym, like nothing changes. So it's where there's a departure in their behavior. And a lot of it will be crying in the bath, it's the signs of crying in the bathroom, coming in late, just the person, it just isn't themselves. And an employer can't ignore that.
Whose responsibility is that? Like, if I see that happening to my colleague, but they are not saying anything and the employer isn't doing anything.
Well, you can't be willfully blind to it.
Yeah.
So, I mean, it's the employer, whoever the employer is, the HR person, Someone who is charged as a partner in a firm, you know, I'm the harassment advisor. So, you know, I'm not, we have HR people, but if the HR people didn't notice it, and I noticed that another, like one of my colleagues just isn't themselves, you know, I'm management of the firm, I'm a partner of my firm. I have an obligation as the employer to say, you know, something's happening with this person, something's not right. I cannot turn a blind eye to that. I can't do it myself personally, but also legally, morally, we have an obligation to investigate. Now, if the person will never share with you what's going on, then you can't force them to. But if there's visible signs that someone is suffering, there's usually a reason for it.
Right.
So yeah, you want to investigate.
Okay. Well, that was a lot to think about.
A lot, and I know,
Thank you so much.
overwhelming, but I'm happy, to take calls another time, or, I'm happy to, if you ever want to talk about anything, I'm happy to be a resource.
That's great. I think that your contact information is there on, well, everyone knows your name, so they can reach you. But that was, yeah, thank you so much. I feel like there's a lot to chew on, and hopefully none of us really have to deal with that, but we are prepared in case we do, and can help our colleagues if they are.
You might want to remind your employers that they need to step up and make sure they have policies in place.
Yeah, I'm definitely going to be asking mine, just to see.
Okay, well, thank you for having me.
Yeah, thank you. And just a few just closing Wia announcements. We have some upcoming events. A Pechakucha on March 24th, which will be a series of, I think we have 8 presenters lined up showing various projects that they're working on from around the world. It should be a fun one. And then the RAIC conference, many of you may know that it's been postponed and not being held in person, so it'll be in June, and Wia is organizing a panel discussion for that featuring some female architects from around Vancouver. So hopefully you can join for those. And mostly just thanks everyone. Thanks for attending, and thanks for being involved with Wia, and especially a huge thanks to Melanie for her time and sharing her knowledge with us. And a final push, always, if anyone would like to volunteer with us, we are happy to take on more people who would like to do things, organize events like this. If there's a topic you are interested in and want to get into, this is a great opportunity to kind of have the resources and format to share that information with your colleagues and community. So you can contact us, volunteer at wiavancouver.org. And thanks everyone for giving us your time tonight.
Thanks everybody.